I do have skills that make me a nightmare for people like you.
So let's see what we can see around the corner here, shall we, people? I doubt very much they've been removed, in which case as I'm driving past you should easily see the road markings on the side. See the yellows along here. Look at that blue car parked there. And look at that, you can see the white lines are still there, people. Can't you? Still there? Yep. Wonder if they got rid of them yet. Nope. Still see him. White marks on that car park are still there. Well, g'day everybody. Part 6 of $60 parking ticket saga. Now we've had a few issues with the hard drive in my computer. It shit itself, so luckily I back up most things, so we haven't lost any information in regards to that. It's just taken me a few weeks to get everything back up and running. Now, where we left off in part 5 was I was sending an invoice to accounts payable for a demand for payment. As you can see there, I'll stick the copy up there. On here I'll read it out to you. By email to accounts payable, apqueries@at.gov.nz. On the 24th of October we received via standard post a notice of an alleged infringement offence issued to our private mode of conveyance associated with registration plate FAN 394. As there is clearly posted on the front and back of our private conveyance notices informing all agents, members, officers and employees of any corporation that by issuing, serving, posting or depositing such an infringement notice shall incur an administration fee of $75. As a tacit agreement has been constituted by Auckland Transport Parking Officer 1126 issuing such an infringement notice, this administration fee is payable within 28 days after service of this invoice demand. Full payment is due by the 24th of December 2018. If we do not receive full payment by the above date, we may advise a debt collection agency to recover the unpaid fee. Please send payment to address. You can alternatively make a payment via direct credit and give them the bank account details and a contact number if they have any queries with a reference number. So that's what I sent off to them. I also sent them a copy of the notice that is posted on the front and back of the car, along with the infringement notice that they sent me, constituting the tacit agreement. Also, a photograph that they supplied me as some sort of evidence that I'm breaching some law, although the photograph doesn't show any evidence of me being parked on broken yellow lines. Note, this notice is clearly visible directly above the registration tag as captured by the parking wall, so because their photo actually captures my notice directly above the registration tag. So they can't say they weren't informed, they took a photo of it. And that was the invoice. I sent that to accounts payable, and I also CC'd it to Vanessa Olovia, the parking prosecutor, just to make her aware as well. I also sent to the registrar this memorandum and notice to exercise pre-existing rights and freedoms affirmed. Okay. What this basically says is, I, Mark Donald Eric, hereby give notice of the defendant Mark Donald Eric Keen's wish to exercise pre-existing rights and freedoms affirmed within the New Zealand Bill of Rights Act 1990, Section 14, to seek, receive and impart information and opinions of any kind in any form, which is reiterated within the District Court's Access to Court Documents Rules 2017, Section 12F. Specifically, to digitally video record the above proceedings by way of one-time digital video recorder mounted on tripod if required, in order to keep an independent and impartial record of the above matter scheduled for the 25th of January 2019 at Waitakere District Courthouse, specific courtroom unknown at this stage, for matters of public interest and to encourage maximum accountability and transparency of fair, impartial and open justice. As the defendant has been informed by the court registry without any reference to a legislative rule or provision that permission to exercise these existing freedoms is to be sought from Waitakere District Court, therefore we request permission from the presiding judicial officer without any waiver or limitations to the aforementioned pre-existing rights and freedoms, with all rights reserved. For the hearing set for the 25th day of January, Waitakere District Court, and I've signed it. I'll be posting up the pictures. I've signed it, CC'd a copy to Vanessa Olivia, and also to Waitakere District Court. So there are two documents I sent through to the courthouse, and combined with that was an attaching email. Greetings, Court Registrar Philippa and Vanessa. Firstly, Philippa, we trust you are in good health. On the 23rd of November 2018, after requesting twice for a hearing to discuss allegations made by a parking warden since the 25th of October, we were granted a hearing. The hearing will be on the 25th of January at 10 AM, according to the correspondence sent to us by Vanessa Olivia. Philippa, given that on the 21st and the 24th of September 2018, while exercising our right, we were harassed on a public sidewalk by your unidentified court security officers. We have concerns for our safety and security from being harassed yet again when we attend on the 25th of January 2019 for this hearing. We ask that in accordance with the Court Securities Act 1999 Section 9(5), that your CSOs have their identity cards visible and respect our access to the public courthouse. We will be attending solely for the matter in regards to Auckland Transport's allegations, although we also attach a notice memorandum seeking permission to record the proceedings, which we comprehend may require this matter to be placed on the judge's list to discuss this request, as has happened to us in past matters. If this is to happen, please inform us without delay of any changes this may occur. We have no intent to cause any disruption to any proceedings and wish to act within the rules and procedures prescribed in law with respect and courtesy. We ask that the court security and staff do the same. Secondly, to the court registrar, please find attached a memorandum in regards to recording the proceedings. Furthermore, we will be requiring a complete transcript of this proceedings and ask that you ensure the court audio recorder is functioning properly, as again in past instances, Auckland District Court managed to lose an entire 5-hour trial due to this error on their part. This would be very much appreciated. Lastly, Vanessa, again we thank you for your multiple correspondences from the 19th of November 2018, I was supposed to write there, which we received on the 23rd of November. Although you have complied sufficiently with Section 2, Subsection 2 of the Act, which we presume you mean the Criminal Disclosure Act 2008, you also mention Section 13(1). Although we have not yet entered a formal plea and a defended hearing has not been set, we appreciate your forethought. Section 13(1) is in relation to full disclosure, not initial disclosure. Should a defendant hearing be set, we will require full disclosure, which you have not yet fulfilled under Section 13(1), as this is to be provided by the defended hearing date. Furthermore, Vanessa, within the initial disclosure you have supplied, which we might add is far more complete than we have had provided by police prosecution services in past instances, The 3-page report states several inconsistencies. However, it does mention that the driver returned and drove off. Does Auckland Transport plan on calling any witness, such as Warden 1126? Will a witness list be forthcoming in accordance with Criminal Disclosure Act Section 13 and its subsections, provided a defendant hearing is set? Under Section 13.3 of the Criminal Disclosure Act, we will require a witness list along with any criminal history related to such witnesses, along with the names of any witnesses that AT does not wish to call upon, or the reasonable grounds for not supplying such. Does AT have any first-hand verifiable witnesses that can verify that Mark Donald Eric Keane was the alleged driver that day? Or is AT solely relying on a presumption under the Land Transport Act 1998 Section 113A? As the defendant maintains the presumption of innocence under the New Zealand Bill of Rights Act 1990 Section 25C and is only liable upon conviction, what actual facts and evidence is AT relying upon? Under the minimal standards of criminal procedure, this will be expected, and as this is an alleged Category 1 criminal offence, the criminal standard of beyond a reasonable doubt will apply. Given there are 2 registered owners, how did AT pick? Will AT be able to prove every element of their allegation? Not to matter, Vanessa, we will look forward to asking these questions and many more in the months to come. We trust you will have a pleasant day. Warmest regards, me. Okay, so I sent that to Philippa, the Court Services Manager, the Court Registrar, and to Vanessa along with those things. So on the 28th of November, in response to that, I got, "Good afternoon, Mr. Keane." This is from Philippa Chapman. "Your matter will be heard in a Justice of the Peace Court." Really? A Justice of the Peace Court? What is a Justice of the Peace Court? I thought it's either a criminal matter, but why is she referring... What the fuck is a Justice of the Peace Court? This is supposed to be a judge-alone trial, so what's a Justice of the Peace even doing there? This is what they do. They stick non-legally trained muppets with black robes to be the banker and make the monetary decision. I will refer your application to the JPs and get back to you once I've had a response. Oh, she's referring it to the JPs. That means she's referring the application to the Justices of the Peace. Okay. I will raise your request with the appropriate manager of the security team and get back to you regarding display of their identity cards. Okay. And that was on the 28th of November. On the 9th of December, I got from Vanessa Olivia, "Good day, I am on annual leave from 30 November 2018 to 7 January. Both dates are inclusive. I will attend to your mail on my return. Should you require urgent assistance, please contact this other chick." Okay, so she's on annual leave. And then I got an email here on the 10th of December from Davina K, Court Registry Officer. So I'm guessing she's one of the court registrars. "Good morning, thank you for your email. Documents have been printed as placed on file." I take it she means "and placed on the file," but either way. So the documents I sent her, please refer to the below PDF 10 December, response to Vanessa and attachments. Okay, now the documents she's talking about being printed on file is this little beauty here that I sent to Vanessa Oliver on the 10th of December in response to her email. By email, "Dear Vanessa, re-Auckland Transport v Mark Donald Eric Keane, CRN number, ICN number. We thank you for your correspondence dated the 29th of November, which we received via post on the 3rd of December. On the 29th of November, in response to that email that I sent to all 3 of them, I got this letter in response from Vanessa. 29th of November, re-Auckland Transport v Mark Donald Eric Keane. Your emails, both received 26th of November 2018, refers, and this is where she starts going point for point. 1. The infringement notice 3066243825 was issued by a duly appointed parking warden pursuant to Section 128D and Section 128E of the Land Transport Act 1998. There is no administration fee payable by Auckland Transport associated with this enforcement. Oh really? So you speak for all companies out there everywhere. You get to dictate what everybody else's administration fees for them is, do you? I don't think so. And besides, there may not be an administration fee payable for the enforcement of such, but it is to the warden's discretion whether or not, and especially and apparently in the evidence, he's stating the driver returned. So why didn't he come up and tell the driver not to park there and not issue an infringement? So the fact that he's saying that they issued an infringement is purely up to the warden's discretion, especially when I know pretty much for a fact, after watching him walk into the courthouse, speak to CSOs, he came straight out and issued a ticket. Okay, there were witnesses the entire time, and a dash cam running on the car. 2. Should the matter proceed to a judge-alone trial? Oh, so we're going back to a judge now? Not a JP trial? Or a Justice of the Peace hearing? These guys need to get their phraseology correct. We anticipate calling Parkin Warden number 1126, Officer Steve, last name redacted, as a witness. 3. The parking warden, Steve, who issued the infringement notice's criminal history, if any, is not relevant to the offence, and the information is withheld pursuant to Section 14.2a of the Criminal Disclosure Act. That Section 14.2a basically states that the prosecutor deems the request irrelevant. Okay? 4. Please also refer to the draft exhibit list, which was included in the full disclosure pack of the 19th of November 2018. 5. Your hearing request dated the 25th of October. Oh, so they got that this time. Because the chick I spoke to on the phone at the end of November said they never received anything, even though they responded to something. So we've got that. Okay, cool. Your hearing request dated 25th of October is deemed to be a not guilty plea, pursuant to Section 13.7b of the Criminal Disclosure Act. Section 13.7b, okay, for those that want to know, states that for the interest of clarity, so there's no confusion, if a defendant requests a court hearing and puts it in writing and signs, that it's deemed to be a not guilty plea. Although, we're still going to a first call hearing, which is a preliminary hearing, where the court needs to have a formal plea entered by the defendant. So her telling me that in writing it's classed as a not guilty plea, then why are we coming to have a plea entered for? What it is for is so the court can gain jurisdiction, because at the moment it's all just in paper. They need to gain jurisdiction over the man representing the name me. So me appearing there puts them in their jurisdiction. That is why they still need a first call hearing and a formal plea to be entered. 6. In response to that not guilty plea, Auckland Transport provided you with full disclosure of all relevant evidence on file for this matter on the 19th of November. No, you didn't. You didn't supply me a witness list, you didn't supply me any criminal history which relates to the credibility of any witness you choose to call. You didn't do any of that. And you've also supplied the draft exhibit list, which is an error. But we get to that in time. 7. Auckland Transport served an infringement notice on you. Well, thank you for your admission. As it said in that previous correspondence, any corporation that serves or issues, so thank you for admitting that in your writing, Vanessa, that you served an infringement notice. And it wasn't Auckland Transport, it was Warden number 1126 that served it on behalf of Auckland Transport, and it was his discretion to do so. By doing so, entered into a tacit agreement to pay my administration fees for your bullshit on demand, which I subsequently sent, and the invoice has been ignored. So guess what? A reminder's coming Auckland Transport's way. Auckland Transport served an infringement notice on you as one of the registered owners pursuant to Section 133A1BI of the Land Transport Act 1998, and on receipt of your signed hearing request, the matter was considered by a prosecutor pursuant to Section 21 of the Summary Proceedings Act. No, it fucking wasn't. On receipt of my signed hearing request, I was sent a bullshit letter back from a parking adjudication team stating that they'd looked at my reasons or explanations, which I never gave, and then they said pay up anyway. No prosecutor pursuant to section 21 looked at fuck all until I sent a second request in on the 10th of December because of the incompetence of Auckland Transport not getting it right the first time. Okay? Just want to get your facts straight, Vanessa. 8. The details of the charge filed in the court are contained in the notice of hearing. That they are. Even the cause and nature, the actual provisions are there. Well done. Better than police. 9. The matter before the court is an infringement offence and not subject to a conviction being recorded. You may wish to seek legal assistance in regards to Section 375 of the Criminal Procedure Act. Section 375 simply refers to the fact that you cannot be incarcerated. It is simply a fine-only matter. You cannot get prison time and no criminal record is recorded for it. It is a moving vehicle violation and it's recorded on that part, your criminal and traffic history. Okay, that's why they separate the two, even though they joined them. Okay, so that was the letter from Vanessa. And then, where are we? And then on the 10th of December, I respond to Vanessa. And this is what I sent her. We thank you for your correspondence dated the 29th of November, which we received via post on the 3rd of December. We shall respond to your correspondence point by point. 1. The infringement notice was issued by Steve, last name redacted, and posted by Auckland Transport. Notice of our administration fee is clearly visible on the front and back of our private motor car. See page 4 of our correspondence dated 13th of November 2018. I'll let the forklift lift out its chunk of wood and then they can piss off and they can carry on. Although Auckland Transport's enforcement of the Land Transport Act 1998 may not incur fees in your opinion, as Steve, last name withheld, while acting in his capacity as a duly authorised parking warden, has entered into a tacit agreement to pay our administration fee by issuing and posting the notice, which is at his discretion to do so. Demand for payment is therefore deemed applicable, not to mention the fact that that notice was illegally issued because there were conflicting signage in what he should have done according to his own fucking manual. And I will point out the parking compliance training manual, all 207 fucking pages of it. According to his manual, he's supposed to have called that sign fault in and get it fixed and not issue an infringement. But perhaps he's lacking his training in his 15 years as working as a parking warden. 44,000 a year, people. That's the minimum. That's the starting wage for a parking warden. 44,000 a year. Get danger pay, get after hours pay. If you work in South Auckland, you get danger pay, and that's not counting tea and coffee. The $1,300 they spend on the uniforms when they start up, it's just gobsmacking. There's 148 parking wardens in Auckland. Raking in a combined total of roughly $20 million a year to run the whole AT thing. And what did they make last year in parking tickets? $60 million. That's over and on top of the $86 million that New Zealand Police made in speed camera infringements. So that's almost $150 million in infringement tickets for parking and speeding. That's ridiculous. Anyway, I'll move on to the letter. Should Auckland Transport not honour this agreement, we will take the appropriate steps to settle this matter through other methods or avenues available to us. The invoice in relation to this agreement entered into by Steve, last name withheld, has nothing to do with yourself, Vanessa, or the allegation made by Auckland Transport against MDE Keane. Perhaps if Steve had read either notice clearly visible on our property, he may have used his discretion more sensibly. The outstanding amount of $75 remains outstanding, and although we appreciate your opinion, it is not relevant. Short of Auckland Transport withdrawing this allegation, this matter shall proceed to a judge-alone trial, even though no judge will be present. We eagerly anticipate cross-examining Steve on the stand while under oath, as we have many questions that require answers. 3. Our request for Stephen's criminal history is not, as you stated, irrelevant, and is deemed relevant as to the credibility of this man's testimony, and is again requested. Upon referring to draft exhibit list included in the incomplete full disclosure pack of 19th of November 2018, we asked the identity of the parking warden who took the 3 photographs from the 15th of November, as well as the relevance. Now these are the 3 photos they took over a month later, okay? As no photographs supplied by Auckland Transport shows any evidence as to an offence being committed, referred to page 126 of the Parking Compliance Training Manual attached with this correspondence. Okay, so I'm attaching that 207 page manual with this correspondence, and the registrar is telling me that they have printed out the documents, so good. The registrar has printed out the manual and they can print out this too, and all of that can go on the record and on file. Additionally, in the interest of full disclosure, we require any brief of evidence related to this matter refer to the Criminal Disclosure Act section 13.3b, notes made at the time by Steve refer to Criminal Disclosure Act section 12.2e, or statement made by him refer to the Criminal Disclosure Act section 13.3a, and to be informed of any convictions that may affect your witness's credibility refer to Criminal Disclosure Act section 13.3d. Thank you for informing us that by requesting a hearing under the Summary Proceedings Act 1957 section 21.6 that it is deemed to be a not guilty plea, although no formal plea has yet been entered. A first call hearing or preliminary hearing set for the 25th of January 2019 will be a great opportunity to have a plea entered formally, along with asking for a Criminal Disclosure Act section 30 order for full disclosure if you continue to fail to supply such until that date. Vanessa, you state Auckland Transport served an infringement notice on you as one of the registered owners. How was this choice made? By drawing straws? This does not satisfy beyond a reasonable doubt, which is not only the minimum standard of in a criminal case, but reiterated on page 157 of the Parking Compliance Training Manual attached. Given it is a 50-50 choice made by Auckland Transport and is based on a presumption which contradicts the defendant's existing presumption of innocence, refer to section 25C of the New Zealand Bill of Rights Act. As we are blessed with the ability to read, we are aware of the information supplied on the charging document, notice of hearing. Is this your response to our request to be fully and fairly informed of the cause and nature of the allegation? We are aware that being found guilty for this offence is not subject to being recorded as a conviction, and although we appreciate your suggestion to seek legal assistance with regards to the above point, we are also aware that any lawyer's first duty is to the court and not to the party they may represent. In previous matters before the court, we have had an amicus curiae who was appointed to assist the court, yet offered by the judge to the defendant for some assistance as well, when in fact the amicus of some 40 years in the profession attempted numerous times to compel a confession from the defendant, amongst other things. However, we enjoyed seeing that matter dismissed as a successful defendant. In conclusion, we will reserve the defendant's right to have free legal assistance to adequately interpret and understand the language used in courts, pursuant to the New Zealand Bill of Rights Act 1990 section 24G. We maintain the defendant's right to be presumed innocent pursuant to section 25C of that same act. We ask, in reference to line 6 of the disclosure index we received from you, noted as defendant's letter received 29/10/2018, with a noted 3 pages in total. This is an error, as the original letter dated the 25th of October 2018, which we shall also attach, is 5 pages in total. The last 2 pages show the P90 area and white markings indicating a parking space in the location of the alleged offence. Why have these pages not been included? Do you have them? After receiving your latest response from the 29th of October, we contacted Auckland Transport via telephone on the 4th of December and asked which lines are relevant, applicable or legal. We explained that upon returning to take photographs for evidentiary purposes on the 24th of October 2018, that the white hockey stick road markings had small X's on them, and the call operator, Kyle, explained that he would lodge a service order to have the white lines removed, as it sounded like they haven't been removed yet. We returned on the 5th of December and took numerous photographs of these markings before they are removed and the faulty road markings are corrected. This may stop any further issuances of infringements in this location where the public have conflicting road markings. Being an enforcement officer for 15 years, we would have thought that Steve knew of this error at that location, yet chose to issue the infringement to the defendant regardless, whereas informing Auckland Transport of the error, as we have, and getting it corrected should have been his course of action. We shall also attach some of these photographs for you to inspect. We also have video documentation for evidence if required. Could you please inform us as to the identity of the adjudicator who authored the Auckland Transport letter dated 3 November 2018, where it has been signed but no name is printed or is illegible? Below are the additional photographs for evidential purposes. And I show him the photo of the van, a couple of vans. The white van there is parked in the spot. I show them the empty spot with little words put in there pointing out the white hockey sticks, and another close-up of the white X's on those white lines. In fact, several photos of those lines and white X's, along with the parking loading zone without arrows, so that's faulty as well. Close-up of the front hockey stick is right there. A good shot taken pretty much like the 15th of November photos they took. I tried to replicate that for them so they can see that as well. But even though their photos clearly show white hockey sticks as well. There's a replication of the first photos they took on the 12th of October, where I was hiding right behind the tree like he was in that little concave there. And there's the photo of the concave where he stood. Okay, so everything is documented. More photos of white X's on the white hockey sticks to be removed. Photo of the cop that decided while I was standing there taking the photos to honk his horn, yell out the window, "G'day Mark!" He must have been a subscriber, but got a photo of him too. No issue there. The P90 zone photo, which seems to be ignored by the parking warden, even though he's noted it in his notes on the record details. And more white lines. More white lines, more photos duplicating their photos, and another shot showing where the warden hid. Such a coward, Steve. Finally, more photos of more white X's on the lines, more photos with lines and prompts pointing to where the spaces clearly marked, and even on the roadside, all 3 spaces occupied in the P90 area, white spaces clearly visible, and you can see the white markings, all 3 are pointed out there. Okay? Last page. Notice. All correspondence shall be published on multiple platforms for maximum accountability and transparency of public services and servants in accordance with New Zealand Bill of Rights Act 1990, Section 14, to seek, receive and impart information and opinions of any kind in any form. Warmest regards, me, CC'd via email to Waitakere District Court at waitakeredcjustice.gov.nz. P.S. Let the car go by. Something to note. Steve was witnessed entering Waitakere District Court, also talking to CSOs prior to issuing the infringement. We have been exercising our rights since the 21st of September 2018, namely videoing and photographing the public courthouse from a footpath and publicly accessible areas on several occasions, and we have been harassed by court security officers for doing so. So we suspect that Steve was told to issue our motor car with an infringement in retaliation. Note that the motorcar at that time had dashcam in operation pointing directly at Waitakere District Court on that date should there be any confusion. We have returned multiple times since and warned members of the public that they too may be issued in error a parking ticket for being in that location, in a way saving the public money and from having the same problems that Steve has caused us. We wonder if Zane or Ashley, Steve's children, would approve of his actions, and how many other erroneous infringements have been issued in his 15 years of service.
The world's on fire, 'cause they lit the spark.